The first option I want to go over for most first offenders in Georgia is a pretrial diversion program. Pretrial diversion is the only one of these options that actually does not involve going to court, going in front of a judge, and entering a more formal plea one way or the other. Pretrial diversion is something that is controlled by the prosecutor's offices, a solicitor's office for misdemeanors, a district attorney's office for felonies. It is controlled by their office, so therefore they set the terms, the conditions. Now there are some requirements under the law, some guidelines they need to follow, but they have large discretion in who they admit into the program and under what conditions. And one of my main jobs is to negotiate on your behalf the terms and conditions that are realistic and perhaps fair given the circumstances of your particular case for you to complete in a diversion program. Now, while I say program, oftentimes these are contracts essentially reduced to writing. All the terms and conditions are laid out, and as long as you complete those terms and conditions, then what we get is a dismissal of your case. Every prosecutor's office, again, has discretion in who exactly administers these cases. So, for instance, in Forsyth County, they actually have in-house personnel that administers the cases and is responsible for oversight. And in some other counties, they actually outsource this to other programs or even probation offices sometimes. There's some important things to remember, though. Number one, diversion keeps you out of court. It is a substitute for going to court. So as long as we're able to secure a diversion agreement, then you will not actually have to go through the criminal justice system the same way as you otherwise would. Number two, the worst that can happen if you fail to complete a diversion agreement in most cases is that you simply have your case put back out into the courtroom, and we do have to go through that process. Number three, it's important to remember that, yes, while you have restrictions and terms and conditions we negotiate, you're not on probation if you're in a diversion program or otherwise sign a diversion agreement. And that is a very big difference for a lot of people, and understandable, because you don't want to be on probation or parole or any of these things people talk about, and you're not going to be. Frequently, diversion agreements are somewhere between almost an instantaneous, where if you turn everything in, your case is closed, up to 3, 6, or 12 months. And I've seen, quite frankly, all of the above be options for how long a diversion agreement goes for, and that's something, again, that I negotiate on your behalf. So, the takeaway here is pretrial diversion, if you can secure counsel and get an agreement for diversion, is a fantastic option no matter the circumstances. It gets a dismissal, and most of the time, most all the time, it's also going to result in a restriction of your charges, meaning your criminal record will be restricted, which under Georgia law is as good as you're going to get, as much protection as you're going to get to ensure that later down the road, no one can use this against you or even access that information. So give me a call if you want to talk about pretrial diversion and whether or not it could be applicable to your case. If you're charged with the first offense, theft crime, sometimes drug crimes, sometimes some sort of family crimes or crimes against other people, these are all particular options for diversion. Unfortunately, in Georgia, if you're looking at this page for DUI charges, there's no diversion available, and that's not something the prosecutor even has the option to do. But on all these other crimes, if you're a first offender, give us a call, give me a call personally, and let's talk about whether pretrial diversion could work for you.